put the weapons off. Except that when General Mbembe received a telephone call, and it's now on the evidence, it was from General Mbombo, his tone changed. And it is an undisputed fact that that entire skirmish, in fact, was a consequence of the police provocatively tear-gassing the mine workers as they were proceeding to the copy. If she had got that report in the way in which no one can, however sanitized the version may have been, she would have known that the police didn't cover themselves with glory in the way in which they handled. So we are saying, over and above what Mr. James has submitted, relevant to her making these statements in that kind of fashion when she has not got the facts, she at least knew now that there have been fatalities already. And therefore, we say she should have been much, much, much more circumspect. Because now the consequence was the worst massacre of mine workers, I mean, in South Africa, in post-apartheid South Africa, since Sharpeville. And that is what that event ends its dubious distinction to. It is the worst occurrence of that nature in a post-apartheid democracy since Sharpeville. No one event is worse than it was. And therefore it called for responsible action. What would have prevented the National Commissioner, may I ask? Simply to have said to the police officers, listen, this is a matter that calls for calm minds, for proper investigation. We have to wait until such time that those who are in authority are in a position to insist. Because this is not something that can be left on the way it is. Until such time as that, please be patient with us. Something like that. But this is inflammatory stuff. Just as inflammatory as the stuff of the minister, who regarded the mine workers and addressed them in derogatory terms. But she clearly associated herself with the attitude of the Minister of Police in this regard. So when we say therefore in 103, that the minister, that the National Commissioner acted with the Minister of Police to undermine, frustrate, and impede the work of the Marikana Commission in both their addresses, it is in that context. We then say that the inference is irresistible, that such statements were designed to tailor a defense for the SAPS at the Marikana Commission, and thus unbecoming of the National Commissioner, insensitive and irresponsible. Now, the fourth term of reference is not entirely different from the third term of reference. This is the one where the report to the President and the media statement subsequently issued on that date was deliberately amended to conceal the fact that there were two shooting incidents, resulting in misleading of the public to believe that all the deaths had occurred at scene one, which arose out of the numbers of SAPS having to defend themselves from an advancing mass. I submit that over and above what we have in paragraphs up to paragraph 112, especially paragraph 12, where we say we submit that the available evidence is sufficient for this board to find, as the Marikana Commission did, that the effect of these changes in the statement is issued to the public was materially misleading because it created the impression that there had been only one shooting incident, which led to the deaths of strikers. The public who had been on television, the shooting at scene 1 would inevitably have concluded that all the deaths had occurred while the police were defending themselves against the militant group which stormed towards the police. The charges were clearly not accidental. The changes were clearly not accidental because, as had been said, the wording of the relevant parts of the statement were otherwise virtually identical. This is in addition to anything that my learned friend has submitted in this regard. Then we make the submission that in 114 that there is no mention of the extraordinary session. I think my learned friend touched on that. Of the NMF.
Yes.
And we also in 115 we say it reads as though there was only one scene where the police were attacked by the strikers and defended themselves. And it again inexplicably makes no mention of the second scene. In 116, I don't have to go through that. 116, we say there were inaccuracies and untruths, actually. And 117,
yeah.
Yes.
I think we covered that extensively.
Yes.
In the debate with Mr.
Indeed.
Jamie.
Indeed. And then, Mr. Chairman, members of the Commission, the Board, we deal with in page 130, we actually show the degree to which that media statement, to the extent that it pleads self-defense or putative, whatever defense may have been held, is on the objective evidence. On the objective evidence, not in keeping with any kind of self-defense, because it's evidence that could easily have been established through the investigations. And in fact, investigations later uncovered those objective facts, because Mpeneni Noki was killed at scene 1. They were shot more than 5 bullets each. And then there were people who were shot from the back. And one I had already indicated was shot so many meters and all of that.
Now we take the point that you refer us to additional evidence which indicated that it could not have been the best of responsible policing.
Indeed. And we would like to draw your attention, Mr. Chairman and members of the board, to paragraphs 134 and 135, where we make our conclusions and submissions, which we argue are in line with your terms of reference.
Yeah. And that's an objective test which you submit here.
Indeed. Now, with regard to 5, we have already in passing indicated just one instance. And Mr. Chairman, the families were clearly not satisfied that the evidence that was tendered by the National Commissioner at the Marikana Commission of Inquiry was not of a nature that would have presented closure for them. And to the extent that one of the important objectives of that exercise, which the President had set the Commissioner to seek to achieve, that was defeated by the manner in which the Police Commissioner testified. And that seriously undermined, certainly, its credibility. And you will see that in these days we talk about accountability. There's been no attempt, even now that the evidence is there. During the commission, and when the commissioner was recalled, all the evidence, even by state pathologists, were ad idem with the pathologist called by the families, which clearly indicated that there are some killings, certainly the killings in the copy, which we did not see in the glare of television.
Scene 2.
Scene 2. It's quite clear there that there is something to be said about the manner in which the police conducted themselves. The National Commissioner didn't seize the opportunity when she had a second bite of the cherry, when she was recalled, to say, may I pause and say, now that I have seen and have evaluated some of the evidence that points to how these people got killed, I have an opportunity to say, this is an opportunity for me to review some of the remarks that I made 12 hours after the killings had been noted. To date, as far as we are aware, that has never been done. So there was an opportunity during the Farlam Commission for her to have corrected the record. Not on what some of the evidence, not on the basis of what the witnesses were saying. There's a witness who actually was saying, some of us in that copy were shot whilst we were having riots. It was Dalimpofu's witness, who had been called by a learned friend, Advocate Mpofu. So, when she gets recalled, this is the point we want to make, she has an opportunity to extend the hand to these families, who had been there for over 300 days.
Unconditional apology, you said.
Unconditional apology.
Yes.
Because now she knows that on a factual basis, concurred on by 2 or more pathologists, one of whom had been engaged by his own department, that some of these deaths can never be explained on any other basis, except that these people who were shot whilst they were fleeing, and some of them were shot in circumstances where it is difficult. I say nothing about some of the things which at that stage had been there. I mean, the classical case is that of Sergeant Sibachani, and I can give the reference to that. A person who was even, it is, who used expletives to describe the number of times he had shot Mpumza. I shot the da-da-da 10 times. That's what it says. Now,
I assume you would agree with this, Mr. Nzebeza, that if, for instance, she was advised by her legal team not to testify to an unconditional apology for fear of later civil claims, then she should have come and said that, so that we know that that is the reason why she did not give an unconditional apology. Would you agree with that?
we would be less constrained in asking for her to be removed from office if we were able to say, because we also have our clients, we're able to say, how much more can she do?
Yeah.
Isn't this the mark of a person who accepts that her office comes with a level of accountability that calls for one to fall on one sword at some stage?
And that's where the buck stops, is it not?
Exactly.
Yeah.
There's no higher official.
Would it be appropriate for an objective assessment to have expected the National Commissioner, once fully briefed with all the facts, the deaths, how it occurred, etc., not only to make an unconditional apology, but also to offer to resign?
Well, I can never be the one to ask anybody to resign from a position to which they are tenaciously holding to. But it would be a mark of honor. I think there would be a lot more respect for her.
34 people died. 34 people died on one day. Isn't that enough for the person at whom the buck stops to take responsibility and say, I resign? Or am I completely off the mark?
A short response, that is true. In fact, if one looks at the fact that within 72 hours, 37 people had been killed. 13th, 3 mine workers by the police, and 32 on the 16th. So, yeah. And within a period of 10 days, 40 people had been killed. 44. So
44
people had been killed.
10 days.
Yes, between the night. You know, His Lordship will know in your career, and it probably is so that in your career you have come across situations where some of us have had to appear or to be represented in a striking of application or an application for one to be suspended. And you will know that there's plenty of authority that says in those kinds of cases, the conduct that is being investigated to determine whether or not the practitioner is still a fit and proper person to, is not only the conduct that triggered the inquiry in the first place, it's the conduct with which the person targeted by that inquiry conducts him or herself during the inquiry in defense.
Yes, I understand that.
And we say those authorities would apply with equal force here.
Yeah.
Because the conduct with which her defense, and I mean, this is nothing to do with who represents her, because they represent her at the instance of what they are instructed to do.
There are 3 Supreme Court cases that have been reported dealing with the question of what a court takes into account when a decision has to be made whether a person is fit for a particular position. I haven't seen anybody referring me to those 3 cases. Do you perhaps have knowledge of them, Mr.
I will dig those authorities, Molo, because they are akin to exactly that which I'm submitting. Because so far, my clients are trying desperately to find where it is that I can show them, other than what they regarded as a shame apology. Where is it that we see any measure of remorse? It is not to date. In the light, in the light of your, Mr. Chairman, our submissions are there.
Yeah.
And in order to leave the podium to my learned friend, Mr. Mpofu, can make use of some of the time I may have left. Those are our submissions.
Yeah.
And we would.
And you stand by them?
We stand by them.
Thank you very much, Mr. Tsibeza. We shall now allow Mr. Mpofu to address us.
Thank you very much, Judge.
Mr. Mpofu, before you start, this question of the political influence, are you going to deal with that?
Very much.
Very much so.
Very much so, and right at the beginning.
At the beginning. Well, then, let me ask you right at the beginning. The whole political influence argument involves a certain Mr. Malema, who is your political head.
Yeah.
Is it appropriate for you, no, serious, is it appropriate for you to make objective submissions to this Board of Inquiry concerning the conduct of your political head?
Well, Chairperson, it is more than appropriate. Actually, I think what is inappropriate is even to have to deal with that issue. I'm sure everyone here has got their political affiliations. They might not be as well known to you but as you said yesterday, none of these people, all the people we refer to, whether it's Mr. Malema, Mr. Ramaphosa, or Mr. Tetwa, it is not their conduct that is before you. All we are interested in this matter is in the peripheral matter of their conduct or involvement, only insofar as it relates to the National Commissioner. That's all. So whether it's a soccer player from Kaizer Chiefs, which I like very much, that who had to deal with her, or whether it was a rock star that I favor, it's got absolutely nothing to do, and it would be inappropriate to even have to deal with that, because all we are concerned with is the matter of whether the National Commissioner, in dealing with my favorite soccer club or my favorite this and that, conducted himself in that way. And I would have expected that matter in any event maybe to have been raised up front or in chambers. But be that as it may.
All right, well then, let us then proceed.
Yes, thank you very much.
And then we shall give you the similar time that we gave you, Mr. Tsibeza,
yes,
which will be, you have to end by the quarter after 3. Quarter after 3.
Well, if it's 1.5 hours, it would be about 10 to 4.
If you're going to deal with one item,
well,
that's sufficient.
Yeah, please, if I may, this is a matter of the utmost importance to the victims of this massacre.
No.
And I would, at the very least, ask that we deal with it on the basis that we discussed in chambers, which is that there be equal time between at least the two intervening parties. And yeah, it until 10 to 4. Yes. Or if we deal on that basis, then on the basis we discuss with you in chambers, then I have at least until about 10 to 4. But in any event, I think we should start. Well, Chairperson, let me start by saying that this discussion, and particularly your views that you have expressed on the question of the very important question of the relevance of the political considerations, is, with the greatest respect, a matter that I want to start with. Maybe let me start by just outlining how I'm going to argue. I'm going to deal, of course, as I've indicated, with the issue of relevance. And in doing that, I'm going to deal with three related topics. One is what I call the fallacies that are doing the rounds here and somewhere else about what the Farlam Commission actually found on this question. You said, for example, earlier, Chairperson, this matter was dealt with Farlam and they said there was nothing in it. I'll show you that that is the furthest finding from the Farlam Commission. And then I'll deal with what I call the constitutional context, which also relates to relevance. Then I'll juxtapose the interests of the direct victims and role players in this matter, whom I represent, with the public interests broadly. I'm not going to spend a lot of time on that. And then I'll deal with the role of political pressure in reaching the decision that we're all talking about of the National Management Forum meeting. So that's the first broad topic, relevance with those subtopics. And then I'll deal with what I call, what is the specific transgression that we are saying the National Commissioner, given all that, what is it that we're saying she should have done or should not have done? And I touched on it yesterday. And then I'll deal very briefly with the failure to testify in relation to this specific matter, obviously, not in the broad terms that my learned friend, Mr. Jamie, dealt with it, rightfully so. And then lastly, I'll deal with whether, in the light of everything else, the National Commissioner is, in our submission, guilty of misconduct and not fit for office. And before I even start, I just want to mention this. If you look at the legislation, section 9, which is why we're here, it deals with, in section 9, it says whether there's misconduct, incapacity and so on, and then, and unfitness. Unfitness, yes. Now, your terms of reference have specifically, whether by design or not, dealt with the question and said, and.
Well, those three terms are repeated in
yes.
the appointment of the Board of Inquiry.
But I'm sorry, Chair. It says into allegations, the very one, of misconduct by the National Commissioner and or into her fitness to hold such office. So
or her incapacity.
Yes, and her capacity, yes. Right. So in other words, we must deal with these things separately. Or you can deal with them jointly, but you can deal with them separately. In other words, even if it was just and, let's assume she was not guilty of misconduct, but only guilty of only unfit to hold office, you would still have to make an adverse recommendation. think that's the simplest way I can explain the relationship between the two. So let's just bear that in mind. And it is in that context that we say this is not a simple disciplinary hearing. So if, and I'm again using a flippant example for emphasis, if the charge, the misconduct was late coming to work, you could still find that, yes, she's guilty of the misconduct, but she's fit to hold office. I won't take it further. I think the point is clear. Anyway, let's go back to the beginning. Chairperson, the fallacy that Farlam did not refer to the political pressure and make adverse findings about it is frightfully impeding the consideration of this aspect. And let me start by saying, if you agree with me, Chairperson, that one of the things that you have to find, or that you are entitled to find, or pronounce upon, is the answer to the question, why? 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 It's all very well. Okay, so she concealed the NMF meeting, but why? So she reasonably foresaw a catastrophe and nevertheless proceeded with it. But why? Why? If this commission is prepared, or at least is not prepared, to blinker itself from that inquiry as to why these things happened, if it is, then I'll stop here. Then that's the end of my debate. But if it is not, then this commission will allow the fact that one of the reasons that informed such concealment, proceeding with the operation irrespective, and all the things that are postulated in the terms of reference, that one of the factors that informed that was this question of the political pressure. I'll go as far as to say, when you talk about the overall testimony, you should be able to find, or at least to allow me to persuade you, that even one of the reasons why she was evasive, as I will read out what all the negative things that Judge Farlam said happened, that even those things were motivated inter alia by the desire to protect the political principles. So if you are prepared to look beyond the narrow wording, literal wording of the terms of reference, but accept that they entitle you to look into, in order to get into your conclusion, to look into the questions of the motives, why she did certain things, then we're in business. Now, what then did Judge Farlam say about the political motive, contrary to popular belief? If you go to
the report,
the report, yes, the Farlam report.
Page?
Let's start at 165.
165.
Judge Farlam says, Chairperson, in so many words, the commission, that means his commission, agrees with the following submissions made by the evidence leaders. Okay? One, that she was unable to provide a coherent, compelling explanation for the sentiments she expressed and testified under oath that. One, then on the next page, the call from Mr. Ramaphosa to the minister did not influence her decision-making in respect of Marikana. So that's a finding of Judge Farlam. When he says, I agree with evidence leaders, that immediately transforms it into a finding by him. So he says he agrees that she was incoherent in relation to the call from Mr. Ramaphosa to the minister that did not influence her decision-making in respect of Marikana. But we'll just pause there, Chairperson, because here we are talking about J 192. I'll qualify everything that I'm saying. Then the following, but when she says she at that stage is talking about General Mbombo. And then go to 543.3 at page 167. That she, again, was responding to what she perceived as pressure from Mr. Cyril Ramaphosa, whom she considered to be politically influential.
Point what? Point 3 or point 4?
That's point 3.
She was responding to what she perceived
as pressure
from Mr. Cyril Ramaphosa,
whom she considered to be politically influential. Then go to the next page, 168.
Well, that's still General Mbombo, no?
Yes, as I've just said. But if your chairperson can be patient,
Yeah.
I'll get there. Go to the page 168.
Yes. I'm there.
Then at paragraph 9, Judge Farlam says,
In their submission.
in the submission, the evidence, you remember she's agreeing with the evidence leaders, also contended that the transcript of the conversation between Lieutenant Mbombo and the Lonmin management shows not only that General Mbombo, as you've just said, took irrelevant political considerations into account in approaching the situation, but also that the National Commissioner participated in inappropriate discussions about political considerations.
Correct.
Okay? So, this is her now, not Mbombo.
But just stop there, Mr.
Yes.
Just stop there. This was placed before the President, who formulated the terms of reference of this particular inquiry.
Yeah.
It could have been the simplest thing for the President to incorporate this finding and ask whether that was in fact so or not.
Yes, it could have been, but even the President cannot be expected to write 500 terms of reference. The question is whether the terms of reference that we contend for are subsumed in what you have in front of you. That's the only question. Not, he can't say, well, now you must say whether he testified on the 3rd of May, on the 4th of May, or he just says the testimony. And therefore, one can't say, well, he could have simply said, go to that date when it doesn't work like that. The interpretation of legal instruments are that you look at what you have and then whether the interpretation you contend for is contained or not.
Correct.
And on that score, once we agree with the methodology of interpretation, then you have to start at term of reference 2.5. which says whether the overall testimony by the National Commissioner at the Commission was in keeping with the office which she holds and the discharge of her duties commensurate therewith. I've just read to you that Judge Farlam at the Commissioner criticized her in relation specifically to this question of the political, the evidence around, well,
But read the last portion of paragraph 9 on page 168 of the Farlam report.
Yes.
This much is clear, they say, this is now the evidence leaders.
Yeah.
Not only from the wording of the transcript, but also from Lieutenant General Mbombo's repeated testimony that she and General Phiyega discussed the possibility of Mr. Malema coming to Marikana and taking credit for diffusing the situation.
Yes, exactly.
Well, despite that, he did not find that that was in fact a consideration that required Mr. Malema, or for that matter, Mr. Ramaphosa, to be drawn into any further inquiries.
No. We're not throwing anybody to any inquiry. We're throwing the National Commissioner Then the question is whether the National Commissioner, whether she did that with Mr. X, Mr. Y, Mr. Z is irrelevant. The question is whether the National Commissioner, as she says, she and the National Commissioner discussed the possibility of a political person coming to Marikana and so on. That's the only issue. It's whether that, in the context of the Marikana, it doesn't matter who the politician is. I can't get this point across more. So it doesn't matter whether it's Mr. Malema or Mr. Maimane. The point of the matter is that to take into account political considerations from whomsoever in the world, Barack Obama, doesn't matter. Is a business of this commission in relation to the National Commissioner. Let's get away from where did the pressure come from for a minute. And maybe let's jump to this, which is also important. I'll come back to it. If you just read the next paragraph. He says...
paragraph 10.
10, yes, Chairperson. Yeah. So, and again, this is a submission by the evidence
which I agree
with which the Commission is in full agreement.
Yes.
We contend that General Phiyega, this person before you, that she was unable to recall this specific context, that she, General Phiyega's testimony she was unable.
No, you're confusing the public. Okay, let me read it. We contend that General Phiyega's testimony that she was unable to recall the specific conversation is both unsatisfactory and unconvincing.
Yeah.
It is, however, telling that she does not dispute the testimony of Lieutenant General Mbombo.
Yes, well, thank you, Chair, for assisting.
So the Farlam Commission dealt with this issue.
Yes.
So why is it not included in our terms of reference?
No, but that is the point. If it was dealt with by the Farlam Commission, it means it is part of the material before you. It means remember what the material before you, as everyone has said, is not just the evidence of the Farlam Commission, but more importantly, the findings. This is a finding that is made.
Correct.
But what is it about?
Tell me where in the terms of reference I must look into that issue.
Okay.
Tell me.
Okay. What is the meaning of the overall testimony? Overall testimony must mean that if there is something in the testimony that Judge Farlam made a finding in respect of the National Commissioner, obviously not all sorts of other things, then that matter is before you. Because he's making a finding in relation to nothing else but that specific matter. But just listen to this. Go to page 169.
169.
Yes. This is another finding with which Judge Farlam fully agrees. He says, we submit on the evidence of the Commission that the Commission should make a finding, which they accept, that
you're confusing the public, Mr. Let me read it.
No, Chair, I don't appreciate this.
But
well, can I, because I want to put my own emphasis where I want to put it.
But then just read what is written.
Yes, it
Please.
says the Commission should make a finding that General Phiyega was complicit in engaging in discussions where political factors were inappropriately considered and discussed in relation to policing the situation at Marikana. This is inconsistent with our constitutional and statutory regime, which requires that policing be conducted in an impartial and unbiased manner.
Yes.
Now, if that is not enough to convince you, Chairperson, that this finding by Judge Farlam, which is adverse to none other than General Phiyega, the National Commissioner before you, is a matter that is relevant before you, then nothing else will be. Because here's a specific finding by Judge Farlam, which says that not only did she do this, but it is inconsistent with the constitutional context. All we want is to say before you, if Judge Farlam is right here with what he says, then she's not fit for office. That's all. That's the only connection between this and you and your Board of Inquiry. If Judge Farlam is correct that what she did was inconsistent with our constitutional and statutory regime, which requires that policing be conducted in an impartial and unbiased manner, a la Section 199 of the Constitution that has already been quoted to you, a la the Police Act. The Police Act says in Section 25 thereof, no member, and that includes the National Commissioner, shall publicly display or exercise support or associate himself or herself with a political party, organization, or movement. B, hold any post or office in a political party organization. C, wear any insignia and so on. D, in any other manner further or prejudice party political interests. It's there, shall, no member shall, and that includes her. Now, if all that read with Section 199 is not what Judge Farlam was talking about when he said her conduct is in conflict with our Constitution, then nothing will ever be. That's the issue. The second issue, I'm sorry, Chairperson. Then goes to a further sign of relevance. If you go to 4, I think it's 445.
Page 465 of the report.
445. Now, at 445, this is what Judge Farlam says. Remember, here Judge Farlam is discussing the National Management Forum, the whole thing about the concealment, which is on everybody's version before you. He says that decision was taken on the 15th, which we all know. But he says the following, very important. 4 possible reasons are suggested by the evidence. And he says that 1 is the desire to preempt the intervention by Mr. Malema to defuse the situation. So that's the first, and it's a political consideration. 2, he says, or the rising costs of the operation, which is not relevant for now. And then 3, or to break the strike, political, but let's say it's not relevant for now. And 4, he says, or pressure or guidance from the executive. Okay? Yeah. Or pressure or guidance from the executive. It can't be clearer than that. Or a combination of all these factors. Now, how can anybody say, if he says those are the 4 possible reasons, how can you choose any one of those 4 and say it's irrelevant to what we're doing here? It's just anyway. Then now this is what then happens. Yes, at 73, Chairperson, I'm sorry, page 452. If you can just jump to page 452.
Yes, I'm there.
Yes, paragraph 73. Again, this is the final nail in the coffin. Judge Farlam says, the Commission is satisfied that those who attended the extraordinary session of the NMF, which is before you, in respect of whom there was concealment, blah, 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 should have been able to tell the Commission the reason or the reasons why, in other words, postulating with those 4, why the decision to implement the tactical option on 16 August, if the strikers did not lay down the arms, was taken, and the only reasonable inference to be drawn from their failure to do so is that they are hiding something. Now, I don't want to go back to where I started. It's your business as to whether that something that was being hidden, one of those things is the motivation to protect political principles, clearly. And then he says, this inference is fortified to some extent, at least by the evidence relating to the missing memory stick. Mr. Jamie made that point. I don't want to belabor it. So there's a relationship between the concealment, whether that concealment is done by means of hiding the memory stick or making it disappear in mysterious ways, as to which of the so-called 4 reasons, one of which is political considerations, is indeed the issue. But let's go to that paragraph, if that is not enough. The commission, and this is another fallacy, because this fallacy, people said the commission had exonerated members of the executive and so on. That was untrue. This is all the commission said. The commission is not able to find that the 4th possible reason for the decision to endorse Lieutenant General Mbombo's alleged proposal, namely what Mr. De Rover called the guidance of the executive, was not one of at least of the factors on which the decision was based. If guidance of the executive played a role, then it is probable that such guidance was conveyed to the NMF by Minister Mthethwa. Right? Following paragraph is important because I think that's the one that caused all the confusion. That says the commission wishes to emphasize that this is not there's a missing word there. A finding.
Start again, please.
That it is not. The commission wishes to emphasize that it is not finding that such guidance was given. If it is, however, unable, in the light of what has been said above, to find positively in Minister Mthethwa's favor on the point. Now, you must juxtapose all that I've just said to you now, Chairperson and members of the board, with respect, with the point, again, which I don't want to belabor, which was made by, forcefully by Mr. Jamie, on the failure of the commissioner to testify. In other words, let's just look at what is in paragraph 74. If Judge Farlam says, I can't find that the political pressure was not one of the factors, then the least that the commissioner could have done in her own testimony would have been to dispel that notion and say, look, we took together 8 factors actually. Judge Farlam is even wrong. And of those 8 factors, none of them accords with what Judge Farlam has found, or whatever. So the failure to testify in this context is important in the sense that the 4 reasons given by Judge Farlam as coming from all these boxes of evidence, one of them is this issue. And it simply cannot be irrelevant if you look at the question of whether the overall testimony by the commissioner at the commission was in keeping with the office which she holds and the discharge of her duties commensurate therewith, one of which duties is to refrain, as I've read so many instruments, from any political partisanship. So one of the duties that must be postulated in term of reference number 5, to be the president could not then list, if we expect the president to say it's commensurate with her duties too, and then list all the possible duties that she must have, then we are being unrealistic. We must accept that when he talks about her duties, he includes therein all the duties that are in the Constitution, all the duties that are in the Police Act, but subject to a constraint only in relation to the Marikana Commission and the evidence. That's all. It's actually not a difficult connection because...
Excuse me for interrupting you.
I'm sorry, Chairman.
No. Paragraph 75 specifically says that the Commission is unable to find that the Minister Mthethwa, who was then the Minister of Police, politically involved, was involved in this decision-making.
No.
That's what he says.
No,
it is, I am unable in the light of what has been said above, to find positively in Mr. Nteto's favor.
That means I'm finding negatively, yes. If you can't find some positively, then you're finding negatively, with respect. You can't, it's unfortunately, those two paragraphs, to be exact, are the worst English. I've looked at this report 1,000 times. But it's an exercise in linguistics. It's an exercise in linguistics to try and find exactly what is being said. But I can tell you one thing. What is being said is that it's not find that it was. You said earlier, double negative. If he says, I'm not able to find that political pressure was not one of the factors. Now,
No, but the first sentence, he says that.
Yes.
He says the Commission wishes to emphasize that it is not finding that such guidance was given. That's political
yes,
guidance.
but you can't just read that out of context, Chairperson. You must read it with paragraph 74. That's all I'm saying. You have to read it with the paragraph 74 where the double negative is. He first says the Commission is not able to find, the word find, that the fourth possible reason, in other words, the political considerations, for the decision to endorse alleged proposal, namely that the rover called guidance, was not one of at least the factors on which the decision was based. In other words, it's a neutral, I think that is what the intention was. It's a neutral statement where he says, look, I can't say the political considerations were irrelevant, to put it colloquially. But I can't positively find that they took place. That is why I'm saying that then calls for an explanation. If he says, I cannot positively find that they were not a factor, that can only mean that they possibly were a factor.
But he says, if guidance of
Yes.
the executive played a role,
Yes.
he doesn't find that it did play a role.
Yeah,
He only speculates if it played a role.
I agree.
Then it is probable that such guidance was conveyed to the NMF
Exactly.
by Minister Nteto.
Exactly.
That's all.
Exactly.
But now you want me, or us, the board, to incorporate an inquiry arising out of this, that political influence played a role, when it's not specifically mentioned at all in the terms of reference. That's what you want us to do.
I'll try once more. I don't want you to do any such thing. All I want you to do, Chairperson, is to accept that given the findings that I've read to you from page 165 to 178, given the reference to the four possible reasons that Judge Farlam postulates, given the fact that he finds that at least possibly the fourth reason played a role, or he cannot find that it didn't. Given those factors, but more importantly, given the fact that he finds that it was inappropriate and that the National Commissioner gave, to put it nicely, unsatisfactory evidence around that question. Given all those things put together, given the fact that your terms of reference in front of you talk about the overall testimony, and they talk about head duties. And we know that head duties, including Section 25 and the 199 of the Constitution, read with 207, include refraining from the very thing that Judge Farlam was talking about, which is why he talks about our constitutional regime. Now, if all of those things are not relevant to, firstly, to the question of the constitutional duties, but secondly, to term of reference number 1, which deals with the concealment of the NMF meeting, where we know the decision was taken, and the question why that concealment might have happened. And I'm proposing to you, Chair, that one of the reasons why that, if Judge Farlam's speculation that it's possible that the political factors were taken into account, then it must follow that one of the reasons for concealing the evidence, for even giving false evidence, must have been to protect the political principles. And I'll refer you to this. I can't remember now because this is from memory. When I cross-examined the National Commissioner, I pointed out, I'll find the reference for you, that very strangely, there were two things that were removed from a statement. One referred to whether she had informed the minister about the
extraordinary meeting decision.
Yes, yes, to go into the tactical.
The D-Day.
Yeah, the D-Day thing. Yes, and then the other thing also referred to, and I'm speaking from memory, to whether after she was told about the massacre on the 16th, she called the minister. Now, that cross-examination was meant for one thing and one thing only. It was to say, even the misleading of the commission in respect to the statements is intended to conceal the political involvement. Because what kind of coincidence can it be that the only two things that are removed are the ones that refer to the minister? I'll give you the reference to that.
Was she cross-examined by you, Mr. Pofu, about the allegations that she succumbed to political pressure?
Yes. She was, and the evidence leaders the evidence leaders here have kindly included that in their, in the exhibit file. I think it's this one. I'm sorry, I'll find it now. Judge Farlam even tried to assist to no avail. This is, you look at, it's on volume 2 of, I don't know what it's called officially. Volume 2 of the footnote bundle of the evidence leaders.
What page?
It's page, let's start at 37483. Or rather, I'm sorry, page 503 of that volume. But of the transcript is 37483. Page 503 of that volume. 503. Yes.
It's cut off. It's cut off. Unfortunately, my copies are cut off.
Oh, I'm sorry.
Okay. No, I've got it now.
I've got it. Okay.
Thank you.
Now, this is where this debate about operational autonomy is not new. You will see that I put it squarely in so many words. I said, yes, thank you very much. This is General Phiyega. I say, okay, let's start at the topic. I say, you would agree surely that what one might call the governance mechanisms of your job and the police come directly from the Constitution, which, among other things, says you must act impartially, without bias, and so on and so on. You agree with that? General Phiyega, yes, I know my constitutional responsibilities and duties.
Where is he reading from now?
I did.
I'm still at the wrong page. I'm sorry.
Well, I'm sorry.
Is it 37483?
That is correct.
Oh, no, I was given the wrong page. Sorry. Yes. All right, now I'm with you. Yes.
I was getting confused myself. Yeah. Okay, at page 37483, I say to her, I'll read it again. You would agree surely that one might call the governance mechanisms of your job and the police come come directly from the Constitution, which among other things says you must act impartially without bias and so on and so on. You agree with that? She says, yes, I know my constitutional responsibilities, about which we've been talking here for a long time. And I say, yes, thank you very much. And you would also agree with Minister Mteto, who puts it even more beautifully than I can, that the constitutional framework of South Africa is such that there must be a clear separation between the operational side of things and the political. And he says at paragraph 16 of his quadruple C1, he uses the nice word to shield. He says, and I quote, the above, after he discusses the constitutional framework, the above makes it clear that the constitutional scheme establishing SABC at its core imbues SABC with a sufficient structural and operational autonomy. I think the word should have been operational. Operational autonomy, so as to shield it from undue political influence through institutional and legal mechanisms. Can't be more beautiful than that. And then General Phiyega, I note his statement and I'm listening. That's the evasive kind of response that you get. And then I said, no. Do you agree that this is the institutional framework under which you as National Commissioner operates? Eventually, it is correct, sir. So it's considered that the political, the separation and the political autonomy question which we invoke, really the only thing we've come here to do, to invoke that principle is applicable. Then I say, thank you. Given that you'd agree that, then you'd agree that anybody who breaks the law or breaches the law in that constitutional and legal framework does not belong in SABC. Again, this is what I've been arguing here all afternoon. If indeed there is that principle which is considered by her, then it must follow that if you breach it, then you are guilty of misconduct at least, or you are not fit for office. That's really the point I was making there, not in so much. There's a place where this record then jumps. But eventually, Judge Farlam tries to intervene. If you look at 37485, Chair, just at the top.
37485.
485, yes. And he says, I think what he means, he now is me. I think what he means is if you are not impartial, if you are actuated by bias, if you allow political factors to operate, which you shouldn't, then you shouldn't really be in that job. You should go somewhere, he should go somewhere else. I think it should be you should go somewhere else. I think that's really his point. Isn't that right, Mr. Mpofu? I mean, this is what we're here about. Judge Farlam was trying to explain in the evidence of the Marikana Commission that this issue has something to do directly with your job, Chairperson, and your esteemed panel, namely to check whether a person who does this belongs in that job or should go somewhere else. That's a polite way of saying, are they fit for office? So not only is it canvassed thoroughly by me in the evidence, then if you go to page 521 of that same document, 520, let's start at, I'm sorry, Chairperson, to do this. Yes, let's start at 520.
520,
yes,
on my copy starts on the left-hand top with page 37487.
That's correct, yeah.
That clear?
Yes.
Right.
So
we're on the right page.
Yes, we are. Those first two pages you can put aside. I'm taking her through Triple J 192 almost word for word, so that's not important.
That's now the conversation that Mbombo told the
Yes.
people about.
Yes,
which she can't recall.
Well, which she can't recall, but in which Mbombo said twice. In my discussion with the National Commissioner, we said, now we can't allow this thing. A, that AMCU must be seen to be ahead of NUM, which is also a political consideration. But also we can't allow this thing that, this one boggles the mind. We can't allow this thing that Mr. Malema can come here and diffuse the situation. I mean, what kind of police person, chairperson, with the greatest respect, let alone a national commissioner, can say that they don't want a situation to be diffused? What is that?
Yeah.
Isn't it? It doesn't matter if it's if it's Mr. Malema or Mr. Terblanche. If you think this person can diffuse this situation, if you are a national commissioner, you say, I want a helicopter right now to fetch that person to come and stop this. You don't say, no, let's go and shoot before that person comes here. What is that? Now, if, chairperson, you're saying that kind of behavior is not covered by the term of reference that say whether this national commissioner was acting within her constitutional duties, then nothing ever will be. We should just all fold our folders and go home. And then, there it goes until again the chairperson intervenes. And you'll see on the next page, chairperson, from 37491 onwards. Judge Farlam tries to give it a stab, but even he did not succeed. But if you go to 37492, where he says, and the point I think, Mr. Mpofu, I'm trying to make it clearer to you because you won't be satisfied to hear me say this, but I'm not sure he's making it as clear as he should. The point he's trying to make is this, that the provincial commissioner, if she's correctly interpreted, was saying that to Mr. Mukona, we've got to deal with this thing tomorrow, we've got to move in, we've got to kill it. Because if we don't, a terrible thing will happen. Mr. Malema will come here, make a speech, and he'll diffuse the situation. He'll get all the credit, and we can't have that. So that is why we have to act now. And this is described as a serious political connotation. I hope you now understand the point he's trying to make. Am I right, Mr. Mpofu? Mr. Mpofu says 100%. And he says, now thank you. And then he, again, I won't bore you, but anyway, the long and short of it is that both the chairperson, Farlam, and myself gave up in the end. And that is why he says that the cross-examination on that crucial point was basically to be criticized. Now, so, Chairperson, honestly, I'm just going to leave it at that because, as I say, if all those submissions don't make it clear.
Heard your enthusiastic
Thank you.
submissions.
Well, I'm saying I'm leaving that point there, not the whole thing. The enthusiasm continues. So now the next issue, Chairperson, is as I've said, I won't dwell now on this exchange between you and I has actually covered the point about whether police autonomy is a constitutional imperative. So I'll jump that. We assume that it is. And so the simple question is that if political autonomy is indeed a constitutional principle, and if, as I have shown painfully and enthusiastically, that it was breached, then isn't the conclusion that should follow from that, in the context of the Marikana Commission, that the discharge of the commensurate duties and so on. And looking at the overall testimony, including what I've just tested, I've just quoted to you, looking at the findings of Farlam, the positive ones. Let's not dwell on that one, which is kind of neutral, because it's one of many, of maybe 10 other findings. Even if you remove that neutral one, in the light of all those findings, whether anybody can still say that this is not a matter to be dealt with here. Now, the role of the next topic, which I said I'll deal with again, I'll be two sentences because I think we've covered it, which is what was the role of the political pressure in reaching the decision of the NMF, and what was the role of the political pressure in the concealment of evidence relating thereto. Now, what is important is what I think it was my learned friend, Mr. Jamie, who said this. If there was political pressure, Chairperson, pressure, what is pressure? Pressure means you must act with haste. Then, at the very least, that must have informed not only the decision at the NMF, but the fact that it had to happen on the 16th, now, as Judge Farlam calls it. And that, we know, is what was part of the disastrous situation. That is what this National Commissioner should have said. Even if she was prone to succumb to political pressure, she could have said, well, but I'm first going to satisfy myself that, and maybe we'll do this on the 17th or on the 18th and so on. So there is a clear, but very clear connection between the notion of pressure, political or otherwise, and the haste which resulted in the catastrophe, as it is referred to in the terms of reference. But secondly, it deals with your term of reference number 2. Again, if you are prepared to ask the question why. If it says it says you must inquire as to whether the decision taken to implement the tactical option ought reasonably to have foreseen the tragic and catastrophic consequences which ensued. And if indeed those consequences were foreseen, as Mr. Jamie once again forcefully argued that they were, one of the explanations as to why, nevertheless, they proceeded with haste with the disastrous consequences must be the fact that there was this pressure being exerted upon them. But if we are not prepared to open to the reasons, in other words, if we are saying, I'll find an appropriate example. If this inquiry was about drug use, and you say, no, we're only going to say we want the people in the street who are selling the drugs, but we're not going to inquire into why the real big lords up there, we're just going to look into this, then it would be a waste of time. When you're inquiring into a problem, you have to find its motive, its underlying cause, let me put it like that, for you to ever be able to pronounce upon it. Otherwise, if you are only prepared to scratch the surface, but never to blinker yourself from looking at the underlying causes for whatever it is that you are inquiring into, then you might as well not do the exercise. So what then is the specific transgression that we say the National Commissioner is guilty of? We are saying it was what I think, Chairperson, you put it better than me. When you talked about succumbing to political pressure, I'm sorry, I'm looking for a note. At 3 a.m. I did manage to put it beautifully, but now the words, yes. It was...
Anyone at the bar knows how to work through the night.
Absolutely. But it can be put like this. It is the idea of bowing to undue political pressure. So it encapsulates the specific transgression. If she bowed to undue political pressure with all what I've said, then she's not fit for office, and she should be discharged. Now, I've already said the failure to testify then becomes important, Chairperson. If in the light of all these findings that Judge Farlam makes about the connection between, and for this, I'm sorry, Chair, you have to look at Triple J 192. And I'll just highlight two words. And it's quoted in the statement of case at pages 114 and 115.
Statement of case or the heads of argument?
Statement of case, Chairperson.
Statement of case.
At page 114 up to 116 thereof.
Page
114.
No, man. Statement of case only goes up to page 122. So 114.
I'm confused.
Sorry.
If it goes to 122, then it must have a 114. I would have thought. But yes. So there.
Yes, I'm there.
Oh, good. Then it says the very first words there, subs commissioner. That's the general bomb. But also remember, from a political point of view, she says, there was even this feeling that, the mining sector wants to replace the NUM, blah, 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 with a new face, and maybe that is why these things are erupting. So I think yesterday, AB will recall, you will recall when the discussion with the national commissioner came.
Who's AB?
AB is one of the Lonmin executives.
Oh, okay.
Remember, this discussion was with a Mr. Mukwena, who was a high-ranking vice president there, who, according to reports over this weekend, was working for state security. So when I said it was a toxic collusion, I might have been understating it. It was actually the state and the state. But be that as it may, he says that you will recall with the national commissioner, when the national commissioner, she being the national commissioner, also from the discussion that she raised with you, and some of these questions that she raised, you remember, I raised them in the morning, and she also felt that, it is difficult to separate management from giving these people a leeway. These people are supposed to be the rivals of the NUM. What kind of national commissioner refers to citizens of the country as these people simply because they belong to a rival political organization?
Is that inference or a reference to AMCU?
Yes. Okay. Again, and then we go to the next page, which is where, again, she's referred to. This is the well-known quotation. When I was speaking to the Minister, Mteto, he mentioned the name to me and is also calling him, that is pressurizing, underline pressurizing him. Pressuring him, yes. Pressuring him. Unfortunately, it is a political high. It is Cyril Ramaphosa. Yes. Now, remember now, when I was talking to the national commissioner last night, she says to me, look, General, who are the shareholders here? And I said, I do not know the shareholders, but I know that when I spoke to the minister, he mentioned Cyril. And then she says, now I got it. She says she got it. You know why she says she got it? Remember, Cyril was in the appeal committee of Malema, yes, and he was very strong and so on and so on. But go to the next page. Then there's that discussion about the diffusing, which we've already referred to. Subs-commissioner in the middle, nationalized and all that. So it has got a serious political connotation, underlying political connotation, that we need to take into account. That we need to take into account, but which we need to find a way of diffusing. Hence, very big word in this context, hence, I just told these guys that we need to act such that we kill this thing. In other words, For these political reasons, hence, I told these guys we need to act in such a way we kill this thing. Mr. Jamie's point exactly.
But that's now Lieutenant General Mbombo speaking.
No, but he's speaking about, let's go back to page 114. He's saying that this is the discussion I had with the National Commissioner in which we agreed on these and these things. Anyway, you'll read it later, Chairperson. At page 116, then he says, I just told these guys we need to act to kill these things immediately. Yes. When tomorrow we have to move in, if today we do not find cooperation in these people, we need to move in such that we kill it, because we need to protect a situation where any jig and jive from a political arena we agreed in the Farlam Commission. So because, not we must move in tomorrow because we must move because we must make sure that the political Jack and Jills are not going to get credit. I mean, really. But, Chairperson, I think I just want to deal with one issue, and it is this. That the bottom line is that our constitution entrenches political autonomy. And that what happened in Marikana is the business of the people that I represent for obvious reasons, because some of them have bullets lodged in their heads and their hips and their stomachs. So they need to know if part of the reason why they have bullets in their heads is because there's a national commissioner who bowed to political pressure, even if it's part of the reason. South Africa also needs to know that. Those who don't have bullets lodged in their heads. And that is why this inquiry is held, so that the country at large should know whether it has the national commissioner that it deserves or not. And part of that inquiry must be as to whether the catastrophe that occupied the Marikana Commission, that is occupying you indirectly, could have been prevented had she performed her duties. It's that simple. And so therefore, it's our business. But also, we're interested in equality before the law as South Africans. We're interested to know whether there is a certain privilege for if you are a senior high-ranking member of the ruling party, and that what you say counts more than if you are myself or somebody else, an ordinary person, such that your word actually can result in a disaster such as this. We need to know this, and you need to pronounce on it as to advise South Africans whether they have the national commissioner they deserve. We need to know whether there might need to be legislative intervention, or yes, there might need to be legislative intervention, or whatever the public can do in order to cure the cancer of political interference. And that is something that is brought specifically by the Marikana Commission. You know, Chairperson, this country, I don't think there's any other country in this world that has gone through the trauma that we've gone through. This is the third national commissioner in succession who has been discharged. The first one was discharged because he succumbed to pressure, let's put it that way, of gangsters, according to the evidence. The second one was discharged because he succumbed to the pressure of business people. It had to do with leases and so on. This is now the third one, and in our respectful submission, she succumbed to political pressure. Something is wrong. And we need, as a country, Chairperson, to know if we bury our heads in the sand and say, no, the president would have written political if he wanted us to find out. Then we are shaking from our responsibility to advise the victims of the massacre, to advise this country, to advise the legislature and all the people who care about this, and that I would dare say includes almost all South Africans who witnessed this massacre on television, as to whether it was partly or to what extent, let's assume it's only 10% of the issue, but whether it was partly or wholly influenced by political considerations.
Can I just ask you a question, though?
Yes.
Was Mr. Selebi a policeman when he was appointed National Commissioner of Police? Did he come through the ranks or not?
Well, no.
No. Mr. Tlele? Did he come through the ranks of the police?
No, Chairperson. It's just to save time. Yeah. But that's exactly, it's correct. What you're saying, Chairperson, is a serious matter. These are the issues I'm talking about. If you, by refusing, as it were, to look into all the issues that might have been at play here, you deprive this country not only of removing or not removing the National Commissioner, but of preempting so that this does not happen again. Remember, one of the functions of this and even the Farlam Commission is to make sure that these things never happen again. And if we bury our sins and hide behind technicalities not to deal with them, then I can assure you we will be here again. It will be 340 people who die, not 34. We are lucky that out of a crowd of 3,000 people, only 34 people died. That might sound like an understatement. But if we do not act, if we allow politicians to make people to violate their oaths of office, such as the National Commissioner had to do, because what she did was in violation of her constitutional duties, but also in violation of her oath. And we submit that a person who is made to do that inter alia by political pressure should not even be allowed to come anywhere near the office of a national commissioner. And Chairperson, with the greatest respect, the country is looking upon the three of you. It's not an easy task. It's looking upon the three of you to inspect all the material that is in the Farlam record, all the material that I've read out to you, and ask yourself whether you, as opposed to Judge Farlam, would be able to say that given all of this, given all the transcript I've read to you, the question of political pressure, A, is not a factor for you to consider, and B, did not play a role in all these things, the concealment of the stick and this, that, and the other, or not. And I implore you, with respect, that you should not make that folly, that you should find that not only is this matter correctly before you, but it is one of the factors upon which, as Mr. Jamie says in his heads of argument, albeit confined to the issue of Mr. Malema. And our job for now was just to expand it, but that is a factor to be considered. Lastly, Chairperson, you must remember that this idea that this matter is not relevant and so on is an opportunistic, if I may say so, afterthought, because when Mr. Jamie pleaded this in the statement of defense, rather in the statement of case, the only response that you have is at paragraph 252 of the statement of
defense.
Of defense, yes. And
200 and?
Paragraph 253. 252 and 253. Thank you.
The one-liner.
The one-liner, which says that after poor Mr. Jamie spent all the time quoting J 192 and so on, it all said the contents of paragraph 187 to 192 have no factual basis, full stop. That's all you have. Nobody says it's irrelevant. Nobody says it is not part of the considerations. They simply say it has no factual basis. And if I have not shown you from reading the record, reading the transcript of the Marikana report, that it has a factual basis, well, then there's nothing more I can do. So they never said that it was not relevant. They simply said it had no basis. And my job, which is the only reason I'm here, was to take you. And I sympathize with Mr. Jamie and even with yourselves that those of us who were in the Marikana Commission maybe are more steeped in the goings on there. And it was our task, and that's why our clients asked us to please come here, and that is why we thank you for allowing us to come here to show you that let's not go through some garden path. The only thing that Judge Farlam said about Mr. Ramaphosa is that we could not show that he intended, he was guilty of murder. But he found, as I've shown you, that the political pressure did happen. Not only did it happen, it was taken into account inter alia by the National Commissioner. Under those circumstances, Chairperson, it is our respectful submission that for the sake of our clients and for the sake of this country, you should find that on the basis specifically of succumbing to political pressure, the National Commissioner, A, is guilty of misconduct, and B, is not fit for office. I thank you very much, Chairperson.
Thank you. Marcelo, I believe that you are responsible for the first response on behalf of the National Commissioner. Let me just ask you, do you want to have a short comfort break or not? Or do you want to carry on?
I think we can all benefit from a short comfort break.
Okay.
Chair, before we do so, can I get a sense? Advocate Mkari and I have had a discussion, and we have tried to estimate how long a combined argument is going to take. Our general sense is between he and I, we can dispose of our argument in about 4 hours, maximum 5. On that basis, we were our thinking, and subject, of course, to your confirmation, was that it's now 3:30. I could take the argument to 4:30 or 5, and because we're starting early tomorrow, we start at 3, then I can finish off and then...
Start at 3? No, start at 9. 9 instead of 10 o'clock.
I wish we were starting at 3.
3 o'clock in the morning is a bit early.
Except for me, Chairperson.
I guess I meant the afternoon, but I still have been wrong, Chair. At 9 o'clock, we think if we can do about an hour and a half today, if we start at 9, we comfortably should finish by lunch.
All right. Let's break for 10 minutes only, and then you can start at 3:45, and then you can run to 5 o'clock.
Well,
And then that gives you an hour and a quarter.
that's fine.
And thereafter, we start to... Silence! 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 Thereafter, we will start at 9 o'clock tomorrow morning.
We're happy to do that, Chair.
Is that in order?
Yes, it is.
All agreed? We'll break for 10 minutes.
All rise.